I want to talk about the declaration for a moment. This declaration that was signed, there's no pretense, which purports to put a cloud on the title. There's no pretense that that was authorized by a board meeting. A corporation can only act through a board. There's not a claim. They just signed it. 4 people signed it and say, nobody can transfer this now. With regard to the removal, the alleged removal, the not-for-profit corporation law provides in 706 the provisions when you can remove a trustee. If you accept that this corporation is bound by the terms of the statute pursuant to which it exists, 706 plus case law, I believe it's the Hayes case, the In re Koch, it's cited in the brief, say that you cannot simply remove a trustee.
What is there in the record that shows that the transfer was intended to promote the interest of the grantor?
The record is rather barren in terms of what the members of the board were thinking at the time they voted. We have, after the fact, arguments by the respondents that this will not be in the interest of the corporation because of A, B, C, D, and E. And what the court did was put itself in the minds of the board, didn't have any evidence whatsoever of why the board members voted. And of course, since we say they applied the wrong standard...
But if you have no evidence of why they did it, how can you make the decision that section the law requires as to whether to approve it non-pro-ton?
It's very simple. Subdivision 8, which governs here, provides that when you have a transfer from one religious corporation to another, the interests of the statute is satisfied if it continues to further religious purposes generally.
Well, how do we know that from this record?
Well, I think it's indisputable that it was a cemetery that both groups, appellants groups and respondents groups, have used since the early 80s, I guess. It continues to be used by both. It was owned previously by the Curious Joel Corporation. They conveyed it because they had financial problems and they had some internal dissension to the Williamsburg Corporation. There's evidence in the record from Mr. Scher, who was present, who was part of the Curious Joel Corporation, that this was done with the intention it was eventually going to come back when their problems were no longer there. There's no change in what the cemetery is going to be used for. It is inconceivable that you could say general religious purposes are not continuing to be served when the exact same use is what's occurring afterwards. There's no discretion involved, is what I'm saying in short.
So this transfer of one-half ownership interest would not affect the Williamsburg community adversely?
I don't believe so, Your Honor. It's going to continue operating as before. They each are permitted to have burials there.
What about selling of cemetery plots? And
what's happening before is from each different communities they bought, the proceeds go into a common pot, and eventually they're split 50-50 pursuant to an understanding that's prevailed for over a decade.
So then what is the change affected by the transfer?
Title. And I believe it may be symbolic to some degree as well. And also I presume that, because I wasn't there at the meeting, I presume that people were thinking if it's commonly owned by 2, there's less chance later on that one group or the other is going to have an argument or a leg up on an argument. All of these things, which are going to the inner workings of this religious corporation.
You keep saying that the transfer, that the relevant section is 12 sub 8. Isn't it 12 sub 9? Isn't this one where the transfer was made without approval and you're being asked to approve it?
I've compressed it, Your Honor. 12.9 provides the authorization for retroactive approval.
But 12.9 says the court may. At least I think it says that.
Yes, and then... But
why is that not a grant of discretion? I mean, do you have cases...
Because 12.8 applies both to approval before the transfer and approval after the transfer, because there's no conceivable basis for having a different standard before and after. It's conceded 12.8 would apply.
Then they both apply.
Excuse me?
12.8 and 12.9.
Yes, as I said, I misspoke. 12.9 provides the authority to go retroactively.
Which is what's at issue here, isn't it?
Yes, but the substance of the retroactive decision-making is also dictated by 12.8.
Well, why shouldn't we look to 12.9?
You are looking to 12.9 as the procedural route. 12.9 incorporates 12.8.
But then don't I have to look for the intention to promote the interest of the grantor?
It's an objective test. By looking at it objectively, you can tell, without going into people's thoughts, will this continue, the same exact use as before the transfer, continue to promote religious objects the same as it did before? The answer is yes. It's used
You
as a
say,
religious
you say that anything that would have been approved under 12.8 must also be approved under 12.9.
12.9 is a vehicle which incorporates
In
12.8,
other
so
words,
I
if-
consider them together.
I mean, is that, I guess, what's your basis for saying that is really my question. Is there a case that says that? It's not obvious to me that you have to use the same test when you're retroactively validating something that was done without following the procedures that you would have used in the first place.
I'm not aware of a case. I can say this. I don't see a principal basis for distinction either before or after. There's no principal basis that I'm aware of. We've cited in a brief the legislative history such as it was. There wasn't much around 1911 when this was added. I'm told there was a fire. We tried to get it from the people up in Albany. As far as we can tell, 12.8, which has this language heretofore provided referring to the approval given prospectively, was just simply added at the end of the statute as it then existed. 12.9 was added later. That has no significance.
Even if we agree with you on the non-justiciability issue, what happens to the declaration?
I believe the declaration that was filed by the 4 members of the congregation, that must be voided in any event because they have no corporate authority to put a lien or put a cloud on title to something that's owned by someone else. They have no authority whatsoever. I mean, I wouldn't say for the judges, but 4 bystanders might just as well have signed this declaration. It's absolutely blatantly unlawful without any corporate authority whatsoever. Thank you, Your Honor.
Thank you. Mr. Mullen?
Their brief misquotes the statute. The statute uses the term conserve, not serve the purpose. To begin with, there are 5 neon signs here, 5 reasons why there needs to be a different standard and there needs to be review. As you pointed out, in 1988, with the same attorney who still represents them now, so they know the process, they transferred the property to the Brooklyn congregation 100%. And they put into their papers before the court and represented to the Attorney General, because there was proper notice to the Attorney General and there was then Supreme Court approval, they said that cemetery is a financial drain. We're suffering financially. The much bigger congregation has the greater ability to handle it. It's a diversion of personnel, etc. And based on those representations, the Attorney General looked at, the Supreme Court judge looked at, and approved it. Now, with full knowledge of the procedure, 19 years later, they go ahead and they do this deed. Now, to start with, there was no notice to the Attorney General, and that is a very important provision. The notice is intended to let the Office of the Attorney General review everything as to the propriety of it. There's a certain number of days that they have to wait. It's not simply a ministerial act. That would diminish the role of the Attorney General unfairly. There's no notice to the Supreme Court. That should tell you a higher level of scrutiny is needed. They waited 4.5 years after the transfer to go do it retroactively on this retransfer. So they waited 4.5 years to seek approval, and that should raise some question. Thirdly, they do so by authorization of Beryl Friedman, the man who really isn't too involved in this case, and Beryl Friedman, who is a person in litigation, who, according to Judge Barish and the Appellate Division, Second Department, turned down their application for a stay. So we are clearly in charge based on 4 rulings of Justice Barish. We've been authorized to collect money and dues for the congregation. We're paying insurance for the congregation as we've done for 6.5 years. We're paying mortgages. We're running schools. We're running health programs for 6.5 years. There was no question. Ray Kelly and the police department knew when there was a riot that we're the ones that needed protection, where they had a level 3 mobilization when they tried to take over the congregation. So here, the person authorizing it is Beryl Friedman, a person involved in litigation at the time. And who does he transfer it to? He comes in and says, notwithstanding the Appellate Division denial of a stay, I am the Brooklyn congregation. It's as if someone comes home and says, walks in and says, I am Judge K. I am Judge Reed. I can't stop them from saying it, but that's what happened here.